Hello all, welcome to Paritranaya. In this class, we shall discuss about an important topic, that is amendment of the Constitution. So whether Indian Constitution can be amended? Yes. But whether the amendment procedure is easy or difficult, it varies. Let us see how we can amend our Constitution. So the amendment of Indian Constitution is neither as easy as it is in Britain nor as difficult as it is in USA. From here, what we understand? We understand that amendment of the Britain Constitution is easy, amendment of USA's Constitution is difficult. Okay. How about Indian Constitution? So Indian Constitution neither flexible, neither it is as flexible or as easy as it is prevalent in Britain, nor it is as rigid or as difficult as it is present in USA. So in India, it is a synthesis of both. It's a synthesis of both. It means few of the provisions can be amended easily and few of the provisions amendment is bit difficult. So when I say easy and difficult, so let us understand this in terms of majority. So whenever I say easy, it means it can be amended with simple majority. Whenever I say difficult, it means it can be amended with special majority. Okay, special majority. Apart from that, we also come across terms like judicial review and all. Okay, judicial review and all. So here we understood that amendment of the Indian Constitution is not as easy as it is prevalent in Britain, and similarly not as difficult as it is prevalent in USA. It's a synthesis. Okay, it's a synthesis of both of them. Okay, both of them. So here, when it comes to amendment of the Constitution, there are two different amendments. Okay, amendments, or two different ways of amendments. So one is under article number 368. Next, other amendments. Okay, other amendments. Amendment under article number 368 and other amendments. So generally when we speak about amendment, we will be referring to article number 368. Okay, article number 368. So whenever we are amending the Constitution under article number 368, it is bit rigid, it is bit difficult. Whereas amending under the other provisions, it is bit easy. So later on we shall see which provisions can be amended under article number 368 and which provisions are amended under other provisions with simple majority. Okay, with simple majority. So here article number 368 deals with the powers of Parliament to amend the Constitution. Okay, to amend the Constitution. So when we say amendment, what do we understand? Amendment means we may add some new content to the Constitution, addition. It may also involve variation. The existing provisions itself, we may slightly vary it, we may change it, or repeal. It means we may completely remove the provisions which are present in the Constitution. So together, addition, variation and repeal, together we use a common word, that is amendment. Okay. So article number 368 speaks about the amendment of the Constitution. Amendment of the Constitution. Next question that arises is whether Parliament can amend the Constitution as per its wish, or does it have any kind of limitations? Okay. So here we need to understand that Parliament does not have enormous or complete absolute power to amend the Constitution. It has its own limitations. Okay. It has its own limitations. Limitations in the form of basic structure. Okay. Basic structure. So what is this basic structure? Whether this term basic structure is present in the Constitution? No, this is not present in the Constitution. But still, this term is very important. So when did this term come into picture? This term came into picture through Supreme Court's judgment in a case called as Keshwanand Bharati case. So very, very important case of 1973. So through this case, Supreme Court gave a word called as basic structure. Okay, basic structure. So what exactly is basic structure, and what is this Keshwanand Bharati case, and what is its relationship with the amendment? We shall see later on. Okay, we shall see later on. But at a superficial level, we shall understand that whenever we are amending the Constitution, we should not alter the basic structure. We should not change the basic structure. So later on we shall discuss about the same. Next, procedure for amendment under Article 368. So whenever we want to bring any kind of changes to the constitution, so it has to be brought in the form of a bill. But what kind of bill? Already we have seen there are three different types of bill: ordinary bill, money bill, and constitutional amendment bill. So whenever we are bringing changes to our constitution, so we have to bring a constitutional amendment bill. So when we want to bring this bill, where we have to introduce it, whether in Lok Sabha or Rajya Sabha. So there is no such hard and fast rule, or there is no such restriction. So the bill can be introduced either House of Parliament. It means the bill can be introduced either in Lok Sabha or in Rajya Sabha. First, if it is introduced in Lok Sabha, then after getting passed in Lok Sabha, it will go to Rajya Sabha. If first it is introduced in Rajya Sabha, then first it will be passed in Rajya Sabha and then it will go to Lok Sabha. Okay, so in any house it can be introduced. Next, very important, it can be introduced in state legislature. Constitutional amendment bills, they cannot be introduced in state legislatures because state legislature do not have the power to amend the constitution. Important point to remember. Next, who can introduce a bill? Minister or private member. So already in the previous class we have discussed the difference between minister and private member. A minister, a private member is one who is not a minister, who is a member of Lok Sabha or Rajya Sabha, but who is not a minister. So here a constitutional amendment bill can be introduced by both minister as well as private member. Okay, there is no such restriction like only minister should introduce a constitutional amendment bill. So both of them can introduce. Next, whether prior president's permission is required. So we have seen that in case of money bill, prior president's permission is required to introduce the money bill. But similar kind of requirement is not there in ordinary bill. So whether similar kind of requirement is there in constitutional amendment bill? No, not required. So prior permission, president's permission is not required in order to introduce a constitutional amendment bill. Next, when it is introduced in each house, in Lok Sabha or Rajya Sabha, with what kind of majority it has to be passed? We have already seen about different types of majority. That is simple majority, special majority, and absolute majority. So if you don't know the difference between these different types of majorities, then you can watch our previous class videos where we have discussed about the different types of majorities. Okay. So here in Lok Sabha and Rajya Sabha, these constitutional amendment bills, they have to be passed with special majority. Special majority. Special majority. Very important. Okay. Special majority. Next, each house, it has to be passed with special majority. Next, need to be passed separately. No joint sitting provision. So we have already seen that there is a provision for joint sitting when there is a dispute between Lok Sabha and Rajya Sabha with respect to certain types of bills. So which bills? Only ordinary bills. Only for ordinary bills, there is a provision for joint sitting. For money bill, there is no provision of joint sitting. Similarly, for constitutional amendment bill, there is no provision for joint sitting. If it has to be passed, then it has to be passed separately in Lok Sabha and separately in Rajya Sabha with special majority. There is no provision of joint sitting for constitutional amendment bill. Very important point to note. Next, the bills which amend the federal features also require states legislature's ratification with simple majority. So what does it understand? What do we understand? So let us take an example. So we know that GST was brought. Okay. So when we brought GST, GST is not concerned only with the center, but it also concerns the states as well. So such a feature, we call it as federal feature. Okay. Federal feature or federal provision. Okay. So this GST is a federal feature. Now, when we brought GST, a constitutional amendment took place. So which was that constitutional amendment? 101 constitutional amendment. So CA indicates constitutional amendment. So when we brought this, we already know in Lok Sabha, it has to be passed with special majority. Special majority. Similarly, in Rajya Sabha, it has to get special majority. Okay, special majority. But before receiving the president's signature, before president signs, in case of GST, it also requires consent of half of the states. It means in India we have 28 states. 28 states, half means 14 states. Okay, 14 states. So at least 14 states should say yes to GST. Then itself constitutional amendment can be brought. So 14 states, in these 14 states, MLAs should vote for it. Okay, should vote for it with what kind of majority? Simple majority. Simple. So MLAs has to vote with simple majority. So what we understood, there are few features which can be amended by the parliament with special majority. It does not require what consent of the states, but there are few provisions which are federal in nature. So such provisions, it requires the permission of Lok Sabha and Rajya Sabha with special majority, and also it requires the permission of at least 14 states, that is half of the states, with what kind of majority? With simple majority. With simple majority. So what is simple majority and special majority? We have discussed in a separate video. You can just refer the same. Okay. Next, with simple majority, president must assent, no withhold. So we have already seen that president enjoys different types of power. What is that power? So whenever a bill is presented to president, he can ratify. Ratify means he will sign it. Next, reject. Reject means he will refuse to sign. He'll say that I will not sign it. Next, return. Return means president will say I am unhappy with the bill, so please reconsider few of the provisions. Okay. So there are various options available to president with respect to different bills. Okay, different bills. But when it comes to constitutional amendment, president should ratify it. President do not have the power to reject it. President do not have the power to return it. Okay, very important. Okay, very important. In the separate class, we have discussed in detail about what president can do with respect to ordinary bill, what president can do with respect to money bill, and also what president can do with respect to constitutional amendment bill. Just as a recap, what we have done, we have understood that president should always ratify constitutional amendment bill. He should sign it. He cannot say no. He cannot reject it. And similarly, he cannot return it back. Okay. So this is the procedure involved with respect to what? Amendment of the constitution under article number 368. Next, types of amendment. As I mentioned, there are two different types of amendment. So amendment which take place under article number 368, amendments which take place under article number 368, next, some provisions, amendments which take place under some other provisions. So under article number 368, there are two types of amendment. Special majority of parliament. Okay, here states are not concerned. Only special majority of Lok Sabha and Rajya Sabha is required, and after that Lok Sabha plus Rajya Sabha plus president. So here also special majority, here also they have to sign with special majority, and finally president will sign. Okay, this kind of amendment is required for few of the provisions, and which are those provisions we shall see later on. Next, there are few other provisions of constitution which require special majority of parliament. It means Lok Sabha plus Rajya Sabha, special majority. Next, plus 14 states. Okay, 14 states, MLAs. So they have to pass in their legislature with simple majority. After that, president will sign it. Okay. So there are two different types of amendments under article number 368. We will be discussing about them later on. Next, some provisions. There are few other provisions in the constitution which do not require special majority. They just require simple majority, like ordinary bill. Okay, like ordinary bill. So which are those provisions? Again, we shall have a look into those provisions also later on. Okay. So these provisions which do not require special majority, so when we make changes to them, such amendments are not considered as amendments under article number 368. It means whenever we change some part of the constitution, with simple majority, such amendments are not called as amendments under article number 368. Very important point to remember. Next, let us have a glance into the provisions which can be amended by simple majority. It means all these things which are listed here, they just require simple majority in parliament, simple majority in Lok Sabha, simple majority in Rajya Sabha, and president's signature. So hence, whenever we are making any changes with respect to these matters, they will not be considered as amendment under article number 368. So which are those provisions? So admission or establishment of new states, alteration of areas, boundaries, or names of existing states. So already we have discussed in the previous class. So what is that? So whenever we want to create a new state, an example is creating Telangana out of Andhra Pradesh. Another example would be creating Uttarakhand out of Uttar Pradesh. Okay. So these are the examples where we have created new state. So when we created new state, did we go for a constitutional amendment under article number 368? No. It did not require an amendment under article number 368. So while creating Telangana out of Andhra Pradesh and while creating Uttarakhand out of Uttar Pradesh, what kind of majority was required? Simple majority was required. Simple majority was required. Next, similarly, abolition or creation of legislative council in states. So we have already discussed that there are few states which have bicameral legislatures. It means both they have a legislative assembly as well as legislative council. So it is not necessary that every state should have legislative council, but all the states will have legislative assembly. So in few of the states where legislative councils are present, so who will create the legislative council? Who has the power to create legislative council? Again, to create legislative council, the power lies with parliament. Okay, parliament. So we have already seen in the previous class, the request will come from the respective state, but the ultimate power to create a legislative council for a state rests with the parliament. So again, when it is creating a legislative council for a state, so it has to pass a bill. Okay, but with what kind of majority? With simple majority. So legislative councils are created by parliament with simple majority. Next, second schedule. So already we have discussed about the schedules. We have 12 schedules, schedule 1, schedule 2, schedule 3 and so on. Totally 12 schedules. So we have discussed about these schedules in a separate class. So you can just watch the video of that respective class to understand about the schedules. So there we have seen that second schedule deal with the emoluments or salaries. So whenever we want to make any kind of changes to these to the second schedule, it does not require special majority, it requires simple majority, and it is not considered as amendment under article number 368. Similarly, quorum in parliament. So already we have seen that quorum in parliament is 1/10. Okay, 1/10 strength. In order to initiate any kind of discussion, we require minimum strength of 1/10. So in Lok Sabha, it will come somewhere close to 55, and in Rajya Sabha, it will come somewhere close to 25. So if at all we want to change these values to 25 to 100, sorry, 25 to 50 or 55 to 100, so 1/10 to 1/5, anything. So these changes can be made by parliament with simple majority. Similarly, if at all you want to alter the salary of Lok Sabha, Rajya Sabha MPs, so that can also be done through simple majority. Next, if you want to change the rules of procedure in parliament, we have a separate book or rules of procedure for Lok Sabha and Rajya Sabha. So whenever we want to change these things, so again that requires simple majority. Next, privileges of parliament, its members and committees. So we have discussed about the various parliamentary privileges. Okay, parliamentary privileges. So there are collective privileges as well as individual privileges. So as an example, we discussed about an individual privilege. That is when the session is going on, Lok Sabha or Rajya Sabha MP cannot be arrested. Cannot be arrested for the previous 40 days and the next 40 days. So these are all privileges. Okay, these are all privileges. So whenever we want to alter the privileges, again, such kind of altering does not require special majority. It requires simple majority. Next, in parliament, should we continue using the English language or not? So this decision can also be made with by parliament with simple majority. So how many judges should be there in Supreme Court? Again, this decision can be made by parliament with simple majority. Next, conferment of more jurisdiction on Supreme Court. So increasing the jurisdiction of Supreme Court can also be done by parliament with simple majority. Now, which official language should we adopt? that decision also can be made by parliament with simple majority. Next, we also discussed about citizenship. There are different ways of acquiring citizenship and different ways of termination of citizenship. Okay, citizenship. So whenever we want to amend these provisions of acquisition of citizenship and termination of citizenship, here also we do not require special majority, but rather we require simple majority. And whenever we are making changes to the provisions of the citizenship, then it is not considered as amendment under article number 368 of the Constitution. Okay, Constitution. Next, election to state parliament and state legislatures. Now we have an act called as Representation of People Act 1950. So what does this Representation of People Act say? It's what it gives us various information, like what should be the eligibility criteria to become a member of parliament, to become member of Lok Sabha, to become member of Raj Sabha, to become MLA, to become MLC. So all these provisions are present in what Representation of People Act. So similarly, if you want to change that act, okay, change that act or provisions related to it, so again it does not require special majority, it requires what? Simple majority. Next, delimitation of constituencies. So what is delimitation of constituencies? So let us assume our Karnataka. So here, what is constituency? So for every constituency there will be one representative, okay, one representative. Now Bagalkot is the constituency, Belgaum is the constituency. So in this fashion, the constituencies, so this drawing of borders is called as delimitation. So this delimitation, provisions related to delimitation, whenever we want to make changes, so that changes can be made with the help of simple majority. So any changes with respect to union territories can be made by simple majority. Similarly, fifth schedule. So we will be discussing about the fifth schedule in detail in the forthcoming classes. Similarly, we will be discussing in detail about the sixth schedule in the forthcoming classes. But we already know at a superficial level that fifth schedule deals with scheduled areas and scheduled tribes. Similarly, sixth schedule deals with the tribal areas in the state of Assam, Meghalaya, Tripura and Mizoram. Okay, Mizoram. So whenever we want to make any changes with respect to the fifth and sixth schedule also, it requires just simple majority and it does not require special majority. Okay. So the provisions which we discussed until now, what kind of provisions are these? So these are the provisions which do not require special majority, but rather they require simple majority. And whenever we amend the constitution with respect to these provisions, those amendments will not be considered as amendment under article number 368 of the Constitution. Okay, of the Constitution. Next, we already seen that under article number 368, there are two different types of amendments. So by special majority of parliament, okay, by special majority of parliament. It means for fundamental rights, whenever we want to amend fundamental rights or whenever we want to amend directive principles of state policy, fundamental rights or directive principles of state policy, we just require what? Parliamentary permission or approval of parliament. So parliament means Lok Sabha and Raj Sabha have to pass them with special majority. Has to pass them with special majority and president will sign. President will sign. So whenever we are making changes to fundamental rights and directive principles of state policy, we do not require state's permission. So state's permission is not required. Okay, not required. Next, we'll come to this point later on. Okay, later on. Next, there are few provisions which require special majority. Special majority of whom? Lok Sabha plus Rajya Sabha and President's signature. Okay. So in Lok Sabha also we require special majority, in Rajya Sabha also we require special majority, and also President's signature is required. Apart from that, we also require consent of half of the states. Okay. Means among the 28 states, at least 14 states should agree. 14 states should agree. So when I say agree, it means these 14 states legislative assemblies. These 14 states have legislative assemblies, right? So these legislative assemblies have to okay the provision, the amendment with simple majority. With simple majority. So which are the provisions in the Constitution which require such kind of majority? Such kind of majority. Okay. Election of president and its manner. So we have already seen how President of India is elected. So who all will participate in the election of president? So in the election of president, we have seen that members of Lok Sabha, Raj Sabha, as well as members of legislative assemblies also participate. So it means, so election of president, it involves federal features. It involves federal features. So whenever federal feature is involved, so only parliamentary permission would not be sufficient. It also requires the consent of half of the states. Okay, half of the states. Next, extent of executive power of union and the states. Okay, so what is the executive power? What are the executive powers between center and the states? We'll be discussing in detail when we start discussing about a topic called as center-state relations. Okay, center-state relations. So here at the superficial level, we shall understand that to what extent executive power of the union and states are there whenever we want to make changes with respect to them. So it requires this kind of majority, special majority plus half of the states consent. So with respect to Supreme Court and High Court, if we want to make any kind of changes, again it requires such kind of majority. Next, distribution of legislative powers or 7th schedule list. Whenever we want to make any changes to the 7th schedule, then only parliamentary permission would not be sufficient, because 7th schedule consists of central list, state list and concurrent list. So whenever we make changes to the 7th schedule, it means we are also making changes to the federal feature. And hence, when we are making changes to the federal feature, only parliamentary permission would not be sufficient. We require consent of half of the states. Okay, states. Next, representation of states in Rajya Sabha. So we have already seen that 4th schedule deals with it. So 4th schedule says that how many representatives should be there from each state. For example, from Karnataka, we have 12 representatives. Similarly, it varies from state to state. So when we are making changes with respect to these numbers, so that requires what kind of majority? Special majority plus half of the states consent. Okay, consent. Next, article number 368, we know that it deals with amendment of the constitution. But if we want to change the provisions of article number 368 itself, that also requires what? This kind of special majority. Special majority of Lok Sabha and Rajya Sabha plus consent of half of the states. Consent of half of the states. Next, very important, amendability of fundamental rights. So, can we amend fundamental rights? Okay. So, let us look into the various Supreme Court judgments. So, when it comes to Supreme Court, it's a very, very important entity, because who is the highest interpreter of Constitution in India? The highest interpreter of the Constitution of India is Supreme Court. So, whatever interpretation the Supreme Court gives, so that is final. That is final and that cannot be questioned. So whenever any doubt arises with respect to the provisions of the Constitution, what we'll do? We'll seek the guidance of the Supreme Court. Okay, we'll seek the guidance of the Supreme Court. So similarly, through First Amendment, okay, through First Amendment, what the government did? Government removed right to property. So when we got our Constitution in 1950, right to property was one of the fundamental right. But through First Amendment, government removed right to property as a fundamental right. Okay, fundamental right. Now, so someone challenged in the Supreme Court that whatever the government has done, it is wrong. So government cannot change the fundamental rights. Okay, so they challenged it in the Supreme Court. So in Supreme Court, it became a case called as Shankari Prasad case. Okay, in 1951. In Supreme Court, a case was filed that whatever the amendment they have done, First Amendment, with the help of which they have changed the right to property, so it is invalid. So they filed a petition in Supreme Court. So Supreme Court gave a judgment. What it gave? It said that constitutional amendments can take away fundamental rights and will not be void under article number 13. Okay, article number 13. So what is this article number 13 says? Article number 13 says that any law which violates fundamental rights should be invalid. Okay, any law which violates fundamental rights, any law that violates fundamental rights is invalid. So in Shankari Prasad case, Supreme Court said that Constitution can take away fundamental rights and will not be void under article number 13. So when you take away a fundamental right with the help of constitutional amendment, then it will not violate article number 13. Okay, this was the interpretation given by Supreme Court in Shankari Prasad case. So it said that article number 13 In article number 13, the laws, the term laws means ordinary laws, and not constitutional amendments, So in Shankari Prasad case, Supreme Court said that constitutional amendments are not considered as laws under article number 13. That is why, so through amendments we can take away fundamental rights. So here in case of Supreme Court, they have the power of what? Review their own judgment. Okay, whatever the judgment they have given in the previous case, that can be returned. Okay, that can be rejected also. Okay, so that the same happened in Golaknath case. So whatever the decision was given in Shankari Prasad case, that was reversed in Golaknath case. So in Golaknath case, 1967. So why did this case come? So Golaknath, he challenged seventh amendment to the constitution. So what did the seventh amendment do? It inserted the ninth schedule. Seventh amendment, it inserted ninth schedule. Okay. So in Golaknath case, whatever the earlier stand was taken in the other case, so that stand was reversed. Okay, that stand was reversed, and Supreme Court said that fundamental rights cannot be abridged. So in the previous case, Supreme Court had said that fundamental rights can be taken away, but in this case, it said that fundamental rights cannot be taken away. So it also said that article number 13 also includes constitutional amendment. So here, in Shankari Prasad case, Supreme Court said that article number 13 does not include constitutional amendments, but in Golaknath case, it said that article number 13 includes constitutional amendment. Okay, amendment. Now, which judgment should we follow? The first judgment or second judgment? So the recent judgment, whatever is there, we have to follow it. Okay, we have to follow it. So now a war began, kind of war between Supreme Court and Parliament. Okay, Supreme Court and Parliament. So Supreme Court said that you cannot take away fundamental rights, but Parliament felt that it is more powerful. So what it did to Supreme Court's judgment, it reacted by passing 24th constitutional amendment. Through 24th constitutional amendment, what the Supreme Court did, it amended article number 13 and also article number 368. So it said that, it declared that Parliament has power to abridge fundamental rights under article number 368. So Parliament through constitutional amendment said that Parliament has the power to take away fundamental rights, under article number 368. Okay, 368. Apart from that, it also said that such an act will not be law under the meaning of article number 13. So whenever we are taking away fundamental rights through constitutional amendment under article number 368, okay, such a constitutional amendment should not be considered as a law under article number 13. So this was the government stands or Parliament stand. So again, next, Keshwanand Bharati case, very important case. So in Keshwanand Bharati case, what happened? It overruled its judgment of Golaknath case. So in Golaknath case, what it had declared? Supreme Court had declared that fundamental rights can be taken away. Okay, cannot be taken away. But here it upheld the 24th constitutional amendment of 1971 and stated that fundamental right is it's not fundamental right. It is that Parliament is empowered to abridge any of the fundamental rights. It means Parliament has the power to take away any of the fundamental rights. Okay, fundamental rights. But apart from that, it also introduced a few important aspects, and that is at the same time laid down the new doctrine called basic structure. So in Keshwanand Bharati, what the Supreme Court did? Supreme Court said that our constitution consists of different provisions. So few of them are basic provisions, part of basic structure. Next, other provisions. So in the Keshwanand Bharti case, Supreme Court said that among the provisions of the Constitution, there are few provisions which are basic provisions and they are part of the basic structure, and other provisions. It said that you can amend the Constitution with respect to other provisions, but you cannot amend the Constitution which alters the basic structure. So very important judgment. You can amend the Constitution, change the Constitution to the extent that it does not compromise with the basic structure. Okay, the basic structure should remain intact. Other provisions you can readily amend it. Okay, readily amend it. So next, Parliament cannot amend or cannot abridge fundamental rights that form part of the basic structure. So similarly, it said that yes, if at all you want to change the fundamental rights or amend the fundamental rights, yes, you can do it. But whenever you are amending the fundamental rights, you should ensure that it does not violate the basic structure. Okay, basic structure. Here we need to remember certain things. Whether the term basic structure is present in our Constitution? No. The term basic structure is nowhere present in our Constitution. Then when did this term basic structure come into picture? The basic structure term came into picture through Keshwananda Bharti case in 1973. So what does this judgment say? It says that you can amend the Constitution, including the fundamental rights, but you should ensure that whenever we make amendments, it will not alter the basic structure of the Constitution. Okay, basic structure of the Constitution. Next, Parliament again it reacted. Parliament again it reacted to the Supreme Court's judgment by 42nd Amendment. So what it said? It declared that there is no limitation on the constituent power of the Parliament. So why Parliament felt that there is a limitation? Because in Keshwanand Bharti case, Supreme Court said that basic structure doctrine. Okay, basic structure. So this basic structure doctrine, it appeared as a limitation on the Parliament. So in order to respond to the Supreme Court's decision, Parliament, it brought a new constitutional amendment and say that there is no limitation on the constituent power of Parliament. It means Parliament can amend the Constitution as per its wishes. There is no limitation on it. Okay, there is no limitation on it. Apart from that, it also said that no amendment can be questioned in any court on any ground, including the contravention of the fundamental rights. So through 42nd Amendment, Parliament also declared that no one can question in any court the amendments which have been made, okay, including the amendments to the fundamental rights. So here Parliament wanted to emphasize its supremacy. But in Minerva Mills case 1980, Supreme Court said that, so whatever the 42nd Amendment was there, it invalidated. So here what do we understand? Supreme Court has the power to invalidate even the constitutional amendment. Okay, amendment. So it invalidated this provision as it excludes judicial review. So in the previous Parliament has responded by saying that no one can question constitutional amendment in any court. Okay, but judicial review is an important feature of the Constitution. Okay, important feature of the Constitution. So whether the term judicial review is present in our Constitution? No, the term judicial review is not present in our Constitution. But through various provisions, we can understand that there is a provision of judicial review. Okay, and what exactly is judicial review? We will be discussing later on. Okay, we will be discussing later on. So here in Minerva Mills case, Supreme Court said that the above 42nd Amendment it excludes judicial review. Okay, it excludes judicial review, but judicial review is the basic feature of the Constitution. Hence, whatever the changes you have brought through 42nd Amendment, that is invalid. Okay, that is invalid, declared Supreme Court in Minerva Mills case. Okay, Minerva Mills case. Next, in this Vaman Rao case, again Supreme Court adhered to basic structure doctrine. Okay, basic structure doctrine, and it clarified that this the concept of basic structure would apply only to the constitutional amendments that have taken place after April 24, 1973. It means before April 24, 1973, whatever the constitutional amendments that have taken place, so basic structure doctrine will not apply to them. But after April 24, 1973, whatever constitutional amendments have happened, so all those constitutional amendments will be subject to basic structure doctrine. It means if these amendments, if they do not touch basic structure, then they will be safe. But if they alter the basic structure, then they may be declared as invalid by the Supreme Court. Okay, Supreme Court. So this is the date when Keshwanand Bharati judgment was given. Keshwanand judgment in case of Keshwanand Bharati case was given. Okay, given. Next, ingredients of the basic structure. So we have already seen that the term basic structure nowhere exists in the constitution. So this term came through Keshwanand Bharati case. So whether in Keshwanand Bharati case did the Supreme Court explicitly mentioned the various provisions which form part of the basic structure? No. Even in Keshwanand Bharati case also, they are not defined basic structure. Then what provisions should be considered as basic structure? Okay. So here from various Supreme Court judgments, the following have been identified as basic features of the constitution. Okay, basic features of the constitution. So it means whenever we are amending the constitution, we should not alter these basic features. So the meaning of each of these terms we will be discussing in the forthcoming classes. Here just we shall have a glance over the various provisions or features which form part of the basic structure. So first one is supremacy of the constitution. So who is supreme in India? Constitution is supreme. Next, so sovereign, democratic and republican nature of Indian polity. Again, this forms part of basic structure. Similarly, secular character, separation of powers, the three organs, that is legislative, executive and judiciary. So separation of powers between them, it is part of basic structure. Federal feature is part of basic structure. All these topics we will be discussing in the forthcoming classes. Next, unity and integrity of nation, again forms part of basic structure. Next, welfare state also forms part of basic structure. Judicial review forms part of basic structure. Freedom and dignity of individual also form part of basic structure. Parliamentary system, rule of law, harmony and balance between fundamental rights and directive principles of state policy, principles of equality, free and fair elections, independence of judiciary. Okay, so limited power to amend of parliament to amend the constitution. So all these are what? Part of basic structure. Next, effective access to justice as well as reasonableness. Next, generally the amendment procedure which is involved, it is generally criticized. So why it is criticized? So let us look into few of the criticisms. Okay, so whether these points are important? Yes, these points are important to some extent in prelims and to a great extent in mains. Okay, great extent in mains. So what are that? So constitution does not prescribe the time frame within which the state legislature should ratify or reject an amendment submitted to them. Now we have seen that certain provisions which are federal in nature, we took the example of GST. So in such cases, apart from Lok Sabha and Rajya Sabha's special majority support required, they also have to get the support of at least half of the states. Okay, 14 states. Now when you send the bill to the states, is there a time frame within which the states have to respond? There is no such time frame which has been mentioned in the constitution. So it means states can take any amount of time, okay, any amount of time and delay the process. So it is one of the limitation, and that is why it is used as the criticism. Okay, criticism with respect to amendment procedure. Next, it is also silent. Constitution is also silent of the whether states can withdraw their approval after according the same. Okay, for example, first let us assume Karnataka state will give its consent for GST. Okay, GST. But later on, if Karnataka wants to withdraw it, so there is no clarity on that. No provision is present in the constitution wherein a state can withdraw the consent which it has given previously. Okay, so all these are used as criticism. Next, few of these points, so they will not be beneficial from prelims. In prelims, they are not going to ask such kind of questions. But in mains, whenever we quote at the appropriate place, so these names, then probably they will enhance the quality of our answer, and definitely they will fetch us more marks. Okay, more marks. So what did K.C. Ware say? So K.C. Ware says that the amendment procedure of the constitution which is prevalent in India, it strikes the balance between flexibility and rigidity. Okay. At the start of the discussion, we saw that amendment of the Indian constitution is not as flexible as it is prevalent in UK, nor as rigid as it is prevalent in USA. Okay. So here K.C. Ware we can mention in our mains answer. Similarly, we can quote Jawaharlal Nehru, where he says that flexibility is required for nation's growth. So if a nation has to make progress and it has to achieve growth, then flexibility is required. Similarly, Dr. B.R. Ambedkar he stated that assembly refrained from putting a seal of finality and infallibility. So Dr. B.R. Ambedkar said that So whatever the constitution we have produced, it is not infallible, it is not final. It may have some kind of loopholes. That is why we have kept the provision of amendment of the constitution. Okay, amendment of the constitution. So all these various quotes of famous personalities can be quoted in our mains answers. Okay. So in this class, we discussed about an important topic, that is amendment of the constitution. We saw different types of amendments. Amendments are under article number 368 and amendments outside the article number 368. We also saw about the basic structure doctrine, okay, which evolved through Keshavanand Bharati case. We also discussed about the various provisions which can be amended under article number 368 and the few provisions which are which do not require amendment under article number 368. Okay. So similarly, in the forthcoming classes, we will be discussing about the important topics related to polity. For all our further updates, subscribe to our channel and hit on the bell icon. Thank you.